What if the one document you believed was unshakable, your United States citizenship, is no longer guaranteed in the way you were promised? For decades, naturalized Americans were told a simple truth. Once you became a United States citizen, your status was permanent. Your oath meant something. Your passport meant security. Your future was locked in. But in 2026, that assumption is being questioned in ways we have not seen in modern United States history. If you are one of the more than 26 million naturalized United States citizens, this is not a hypothetical discussion. This is a real policy shift with real legal consequences, and it is already unfolding. Today's video is not speculation. It is not opinion. It is an analysis grounded in federal law, USCIS policy direction, and Department of Justice enforcement priorities. And if you are part of immigrant communities like Indian Americans, who represent one of the fastest growing naturalized groups in the country, the implications are especially significant. Stay with us, because understanding what's happening now could determine how secure your future truly is. Welcome back. Again, welcome to USA Embassy Updates, your trusted source for clear, fact-based updates on United States immigration law, visas, green cards, and citizenship. Our goal is simple: break down complex government policies so immigrant families can understand what is changing. Today's topic has triggered anxiety across immigrant communities nationwide. It involves a legal process most Americans never expected to face after becoming citizens: denaturalization. This is not about border crossings. This is not about asylum seekers. This is not about undocumented immigration. This is about Americans who already are citizens. What is denaturalization? And why is it back in the spotlight? Under United States federal law, denaturalization is the legal process through which the government revokes citizenship from someone who became a citizen through naturalization. Historically, this authority was used extremely sparingly. For decades, it applied almost exclusively to individuals who concealed serious criminal activity, people who committed intentional and material fraud, cases involving national security or war crimes. In other words, it was meant to be rare, a legal remedy for the most extreme violations. That understanding is now changing. The 2026 shift from rare exception to systematic enforcement, internal operational guidance circulating within USCIS field offices, signals a major departure from past practice. Under this new enforcement framework, immigration offices have been directed to actively identify potential denaturalization cases every month and refer them to the Department of Justice. The numbers matter here. Field offices are being instructed to flag approximately 100 to 200 cases per month, nationwide. Once identified, these cases are forwarded to Department of Justice attorneys for possible prosecution in federal court. To understand how dramatic this change is, consider this. From roughly 2017 through 2024, the total number of denaturalization cases filed across the entire country was only around 120 cases. That averages out to fewer than 20 cases per year. Now compare that to 1,200 to 2,400 cases annually under the new targeting framework. This represents a massive escalation, not incremental enforcement, but an entirely different approach. Why legal experts are raising red flags? Federal law is very clear on one point. United States citizenship can only be revoked if it was illegally or fraudulently obtained. That means honest mistakes are not supposed to qualify, clerical errors are not supposed to qualify, confusion, memory gaps, or misunderstandings are not supposed to qualify. The standard has always been intentional deception involving material facts. But here's the concern legal scholars and former immigration officials are raising. When agencies operate under numerical targets, the definition of fraud can quietly expand. When officers are expected to find hundreds of cases every month, the incentive structure changes. Routine inconsistencies that were once resolved administratively may now be interpreted as evidence of misrepresentation. This is not theoretical. This is how quota-driven enforcement works in practice, how decades-old applications are suddenly back under review. Many naturalized Americans applied for citizenship 10 years ago, 20 years ago, even 30 years ago. Those applications were often completed in a second or third language without legal representation, using paper forms. Based on memory, not digital records. Minor inconsistencies were common, dates slightly off, travel history incomplete, job titles described differently, addresses abbreviated or shortened. Under past standards, these issues were resolved during processing, or ignored if immaterial. Under today's enforcement posture, those same discrepancies may be re-examined through a far more aggressive lens. A scenario that is now legally possible. Imagine this. You immigrated legally, you obtained permanent residence, you waited the required years, you passed your civics test, you took the oath, you have lived as an American for over a decade. Then, during a review of historical files, an officer notices that one short international trip was not listed correctly on your naturalization form. Not because you lied, but because you forgot. Under the old system, this would almost certainly never surface. Under a quota-driven denaturalization initiative, it may be flagged as a material inconsistency worthy of referral. That referral alone does not revoke citizenship, but it begins a legal process that can be life-altering. The government's official justification? Federal agencies have made their position clear. According to USCIS and DOJ statements, denaturalization efforts are intended to protect the integrity of the immigration system, identify individuals with serious criminal histories, and address cases involving fraud, violence, or national security risks. Officials argue that citizenship obtained unlawfully was never valid to begin with. From a legal standpoint, that argument aligns with existing statutes. The controversy lies not in the authority itself, but in how broadly and aggressively it is now being applied. Why this policy is different from past immigration crackdowns. Previous enforcement initiatives focused on border controls, visa restrictions, asylum processing, and entry bans. Those measures targeted who could enter the United States. This initiative targets who gets to remain American. That is a profound shift. Naturalized citizens have historically been considered fully equal under the law, indistinguishable from native-born citizens in terms of rights and security. Systematic denaturalization efforts challenge that assumption. The numbers behind the anxiety: there are approximately 26 million naturalized U.S. citizens today. Each year, hundreds of thousands more take the oath. Among these groups, Mexico is the largest source country, and India ranks second. In recent years, tens of thousands of Indian-born immigrants have naturalized annually, making Indian Americans one of the most legally exposed communities under expanded denaturalization review. Many waited over a decade due to employment-based green card backlogs. Citizenship represented the end of uncertainty. Now that certainty is being questioned. The psychological and social impact. Immigration attorneys report a growing sense of fear among naturalized Americans. People are asking questions they never expected to ask. Should I avoid international travel? Could updating my address trigger scrutiny? What if two old forms don't match exactly? What if my name appears differently on documents? Experts warn this creates a chilling effect, discouraging lawful engagement with government systems and undermining trust. Bigger questions for American democracy. Wow, this policy shift raises fundamental questions. Is U.S. citizenship conditional for some Americans? Does this create two classes of citizens? Can allegiance be retroactively questioned decades later? These are not abstract concerns. They affect families, careers, property, and futures. What naturalized citizens should know right now? This is not legal advice, but, informed awareness matters. Naturalized citizens should maintain copies of immigration records, understand their application history, seek qualified legal advice if concerned, and stay informed as policy challenges unfold. American citizenship has long been viewed as permanent and secure. In 2026, that perception is evolving. This does not mean mass denaturalization is inevitable, but it does mean the legal landscape is changing in ways that demand attention. At USA Embassy Updates, we will continue tracking court challenges, DOJ enforcement trends, and USCIS policy updates. If this information was helpful, share it with your community. Awareness is protection. Subscribe for verified updates and stay informed, because in today's immigration system, knowledge matters more than ever. Thank you for watching. Stay prepared, stay informed, and we'll see you in the next update.